Hello there. Welcome to today's episode of An Interesting Case. Today we will be dealing with the case of the Unwelcome Inspector, or as it's known in legal circles, RV Bichel. And it deals with the question, does a building inspector need a warrant to enter your property? This case will specifically deal with the law in British Columbia. Um, and the law in other provinces may vary depending on the local legislation there. And the case arose in the 1980s in the District of North Vancouver. In the case, and I will mention also that normally I have a blog that goes along with these videos so people can read the case in written form. Unfortunately, I don't have time to do that today, but I will get back to doing that in the future, hopefully. I will have links to all the references that I use in the description of the video and also in the credits at the end, though, so people can read up on these things themselves. So, anyways, the case began in the 1980s in the District of North Vancouver. The building inspector for the district was charged with enforcing, amongst other things, the city's zoning bylaw. And he decided that he wanted to enter the property, the residence of Mr. Bichel, to see if it had an illegal suite or not. Now, he went to Mr. Bichel's property on 3 different days to ask permission to enter. The bylaw in the zoning bylaw said that the building inspector had the right to enter the property at any reasonable time to inspect for compliance with the zoning bylaw. But the property owner would not let the building inspector in on any of the 3 days that he came there because the building inspector did not have a warrant and he objected to a government official basically being able to come in and look around without a warrant. Um, the property owner, Mr. Bichel, was prosecuted for violating the zoning bylaw by obstructing the building inspector from coming in to perform his duties. And during the trial in the provincial court, Mr. Bichel argued that, despite what the bylaw says, that the building inspector has the right to come in, it's not right for him to do so. It's an unreasonable thing. It violates his rights under the Canadian Constitution, specifically under Section 8 of the Charter of Rights and Freedoms, which is the part of the Canadian Constitution that outlines basic, fundamental, and important rights that are constitutionally enshrined. And Section 8 says that a person has the right to be secure against unreasonable search and seizure. And generally, the courts have interpreted this to mean that if a government agent wants to enter property without the owner or occupant's permission, they need a warrant, normally. The provincial court agreed with Mr. Bichel and threw out the bylaw and said that the bylaws, even though the bylaw said the building inspector had the right to enter, it was violating Mr. Bichel's charter rights, and therefore the bylaw was invalid. So, of course, the city government, the municipal government, was not happy with this, and they appealed to a higher level court, the BC Supreme Court, and the BC Supreme Court overturned the lower court's decision, saying that no, it was not a violation of charter rights. It was acceptable for the bylaw to allow for an inspection of a house without a warrant. Eventually, it wound its way up to the British Columbia Court of Appeal, the highest court in the province. The only way it could go any higher is if it were to be appealed to the Supreme Court of Canada, the highest court in the country, but it was not. In 1986, the British Columbia Court of Appeal came down with a ruling that no, constitutionally, you do not have a constitutional right to keep a local government official like a building inspector out of your property or out of your house uh, without a warrant. So that is to say, a local government official can come in and inspect your house without a warrant. It's not constitutionally prohibited. There just has to be a reasonable law in effect with reasonable parameters. Um, and as long as there is such a law, those kind of searches without a warrant are permissible. The reasons that the British Columbia Court of Appeal gave, is that to treat these sort of bylaw searches differently than they would a police search is is interesting because you would think that if a police officer can't come and search your property without a warrant, how come a building inspector or a bylaw officer can? But they can in British Columbia and also in other provinces of Canada. And that's because the courts have found, as the British Columbia Court of Appeal found in this case, that bylaw searches are not criminal investigations, they're administrative regulatory investigations. And therefore, the level of privacy um, protection needed is lower. And some of the differences that they gave are that one, these kind of regulatory uh, inspections are less intrusive. They don't go in looking into every little aspect of your life in your private space. The building inspector just wants to look at some wiring, some plumbing, and then he's gone. Also, another reason they gave is that there's much less stigma attached. If you're found to have violated a bylaw, it's much less of a big deal and much less stigma than if it's found that you've committed a robbery or drug trafficking or some other crime. So the stigma is much lower. And also, they also found that a lot of the bylaw inspections were random in nature. They were spot checks. And so it didn't really make sense to go through a big bureaucratic process of obtaining a warrant when, these are random checks that just are part of the routine. So those are the reasons, the rationale that the Court of Appeal gave in the Bichel case to say that no, administrative searches like bylaw inspections and building inspections don't always need a warrant as long as there's a reasonable law and a reasonable framework in place. And you will see that in the current day in the province of British Columbia, in the community charter in section 16, and in Section 419 of the Local Government Act, local governments in BC are continue to be given the right um, to conduct searches of private property without warrants for regulatory purposes. There are some limits placed on the local governments in those statutes. For example, the statute says that the searches have to be done at a reasonable time, they have to be conducted in a reasonable manner, etc. But you don't need a warrant. So as long as you're not showing up in the middle of the night to do a surprise inspection and demanding that the owner get out of bed and you know and that kind of thing, as long as you're acting in a reasonable way and you give the owner reasonable accommodations. If the owner says, "Hey, I'm busy today. I can't do the inspection today. Can you come back next week?" As long as you're acting reasonably and then you are allowed to do those kind of searches without a warrant. There are also some more restrictions in place if you're trying to search inside somebody's home and conduct a bylaw inspection in a home. Um, you generally need to give a little bit more advance warning there, 24 hours warning normally. Uh, and there are also cases where the courts have said that something you may need a warrant for an administrative search if it starts to get into criminal territory, even if it started off as a regulatory matter. For example, in RV Arkansas, which I don't have time to get into, sorry, not RV Arkansas, in this case of Arkansas versus the city of Surrey. In that case, there was a search that was regulatory in nature, but it got into the criminal realm. But unfortunately, I don't have time for that today. Maybe another time. And I hope you found my episode today of An Interesting Case useful. If you did, please consider giving it a like and a comment and subscribing for more like it. And in the future, I hope to get back to a more professional format where everything is more structured and also on blog format. Thank you, and that's all for today. Talk to you next time.